Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. Section 238 of the Code IBC 2016 explicitly states that the provisions of IBC will prevail over any inconsistent provisions in any other law in the country. However, the interplay of IBC with the other laws in the country has other dimensions too. So friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Code IBC 2016 and to navigate through the intricacies of its proceedings. So let us today discuss one such case. So this is the case of National Spot Exchange Limited versus the Union of India and others, which was decided on the 15th of May 2025 by the Honorable Supreme Court of India. Now, what were the issues before the Honorable Court? Can the provisions of a law or act be circumvented or ignored while exercising the powers under Article 142? What is the scope of Article 142? How will the statutes be interpreted where two legislative fields have apparently overlapped? Whether the SARFAESI Act or the RDB Act prevails over the state legislation, that is MPIDD. Whether the priority under Section 26E of the SARFAESI Act 2002 be given in respect of properties attached under the MPID Act. Whether there is any overlap or inconsistency between the provisions contained in the IBC and the MPID Act. Whether the properties of judgment debtors and garnishes attached under the MPID Act would be available for the execution of decrees against the judgment debtors in view of the provisions of moratorium under Section 14 of the IBC 2016. Now let us see the factual background of this case. In April 2012, the Department of Consumer Affairs issued a show cause notice to National Spot Exchange Limited, NSEL, a spot market for allegedly violating the exemption terms. In July 2013, the department instructed NSEL to halt new contracts and settle the existing ones, after which NSEL suspended operations on 31st of July 2013. Criminal complaints, enforcement actions, and lawsuits followed, as approximately 13,000 investors claimed that they were defrauded by 24 trading members, leading to defaults of approximately Rs 5,600 crores. In the process of recovery proceedings filed by NSEL, the decrees and the awards of about 3,365 crores out of Rs 5,600 crores were passed against the defaulters. The Enforcement Directorate attached assets worth approximately Rs 1,740 crores of the defaulters under the PMLA 2002. Now, the state of Maharashtra, under the provisions of the Maharashtra Protection of Interest of Depositors in Financial Establishments Act 1999, had attached movable and immovable properties worth Rs 8,548 crores belonging to 24 defaulters, the directors and sister concerns of NSEL. NSEL filed a writ petition seeking consolidation of all related cases before a committee set up by the Mumbai High Court. So we come to the constitution of the Supreme Court Committee. On 4th of May 2022, the Supreme Court, exercising its powers under Article 142, passed an order constituting a Supreme Court Committee. The Supreme Court Committee raised an issue as to whether the secured creditors would have priority of interest over assets attached under the provisions of PMLA 2002 and the MPID Act by virtue of the provisions of the SARFAESI Act 2002 and the RDB Act 1993. Now, by order dated 10th of August 2023, the Honorable Supreme Court Committee concluded that given the overriding effect, the secured property being in the nature of proceeds of crime as held by the attachment orders, no priority of interest can be claimed by the secured creditors against such attached property. The SC Committee further concluded that the provisions of the MPID Act would override any claim for priority of interest by the secured creditors in respect of the property which has been attached under the MPID Act. The SC Committee, by the order dated 8th of January 2024, further concluded that as regards the properties which were attached under Section 4 of the MPID Act prior to the imposition of the respective dates of moratorium of the judgment debtor or garnishee under Section 14 or Section 96 of the IBC, the property having been vested in the competent authority appointed by the state of Maharashtra, such properties were not liable to be made part of the insolvency proceedings. Further, that they could be available to the said committee for realization in terms of the order dated 4th of May 2022, passed by the Honorable Supreme Court. It further concluded that as regards the properties which were sought to be attached after the date of commencement of moratorium, or assets of the judgment debtor, or the garnishee, or the corporate debtor, which were not yet attached under the provisions of the MPID Act, the decree holder would be entitled to pursue its claim as a financial creditor or a secured financial creditor, as the case may be, in such individual cases under the provisions of the IBC. Now, what was the decision of the Honorable Supreme Court? First, can provisions of a law or the Act be circumvented or ignored while exercising the powers under Article 142? What is the scope of Article 142? Article 142 cannot be used to achieve something indirectly, what cannot be achieved directly. The Honorable Supreme Court held that while exercising the powers under Article 142, the express provisions in the other relevant statutes should not be ignored, particularly when the exercise of powers under Article 142 would directly be in conflict with what has been expressed provisions in such statutes. Further, the next issue, how will the statutes be interpreted where two legislative fields have apparently overlapped? Now, in terms of distribution of legislative powers, situations have arisen where two legislative fields have apparently overlapped. Now, it is right that the court, while interpreting the statutes which have conflicting provisions, has to consider the federal structure embedded in our Constitution as a basic structure. A threefold distribution of legislative power between the Union and the states made in the three lists in the 7th schedule of the Constitution, read with Article 246, exhibits the principle of federal supremacy. That is, in case of inevitable conflict between the Union and the state powers, the Union power as enumerated in List 1 shall prevail over the state power as enumerated in Lists 2 and 3. And in case of overlapping between Lists 2 and 3, the latter shall prevail. Now, the next issue, whether the SARFAESI Act or the RDB Act prevails over the state legislation, that is the MPID Act. The MPID Act is relatable to the state list, List 2, of the 7th schedule of the Constitution of India. Both SARFAESI and RDB is relatable to banking, falling in the Union list, List 1 of the 7th schedule. The central legislations, that is SARFAESI Act or RDB Act, cannot be permitted to prevail over the state legislation, that is MPID Act, merely because the central legislations are enacted by the Parliament. Since all these acts have separate field of operations, provisions of SARFAESI Act or RDB Act cannot be permitted to override the provisions of the MPID Act, which is a validly enacted state legislation. Otherwise, it would tantamount to violation of federal structure doctrine envisaged in the Constitution. Based on the respective legislative powers of the Union and the states as given in Articles 245 to 254 of the Constitution, the state, qua the Constitution, is federal in structure and independent in its exercise of legislative and executive powers. The SARFAESI Act and the RDB Act, having been enacted by the Parliament for the subject matter falling in List 1, and the MPID Act having been enacted by the state legislature for subject matter falling in List 2 in the 7th schedule. The latter would prevail in the state of Maharashtra in respect of the specific subject matter for which the said act was enacted in view of Clause 3 of Article 246. Now, whether the priority under Section 26E of the SARFAESI Act 2002 be given in respect of properties attached under the MPID Act. In the instant case, the properties have been attached under Section 4 of the MPID Act. Such properties have been acquired by the financial establishment, that is NSEL, either in its own name or in the name of other persons, from out of the deposits collected by the financial establishment. All such properties and assets of the financial establishment vest in the competent authority appointed by the government, pending further orders from the designated court. Such monies or deposits of depositors or investors who have been allegedly defrauded by the financial establishment and for the recovery of which the MPID Act has been enacted. Therefore, these could not be said to be a debt contemplated in Section 26E of the SARFAESI Act, and hence also the provisions of Section 26E could not be said to have been attracted. Therefore, the Honorable Court held that no priority of interest can be claimed by the secured creditors in terms of Section 26E of the SARFAESI Act against the properties attached under the MPID Act, and the provisions of the MPID Act would override any such claim for priority of interest by the secured creditors. Now, whether there is any overlap or inconsistency between the provisions contained in the IBC and the MPID Act, the issue of repugnancy or conflict, as contemplated in Article 254, would arise only when the state legislation and the central legislation both are relatable to the entries contained in List 3, concurrent list of the 7th schedule. The subject matter of IBC being bankruptcy and insolvency is relatable to List 3, that is the concurrent list. The MPID Act having been enacted for the matters relatable to List 2, state list, and the IBC having been enacted for the matters related List 3, concurrent list, the provisions of Article 254 would not be attracted. Thus, in the instant case, there is also no overlap or inconsistency between the provisions contained in the IBC and the MPD Act. Further, the provisions under the IBC arise out of the debtor-creditor relationships of the parties. As per Section 14 of the IBC, which pertains to the moratorium, a declaration has to be made to an order by the adjudicating authority prohibiting the acts mentioned therein. Therefore, Section 14 of the IBC is consequent upon the order passed by the adjudicating authority declaring moratorium. However, so far as the attachment of properties under Section 4 of the MPID Act is concerned, it is beyond the realm of the debtor-creditor relationship as contemplated in IBC. A conjoint reading of Section 4, 5, and 7 of the MPID Act makes it clear that though Section 4, subsection 2 of MPID states about the attached properties being vested in the competent authority appointed by the government, such vesting would be subject to the orders passed by the designated court. The Honorable Court therefore sees no inconsistency between the provisions in the MPID Act and the IBC. In the absence of any inconsistency between the provisions contained in the MPID Act and the IBC, Section 238 of IBC, which gives overriding effect to the IBC over the other acts for the time being in force, cannot be said to have been attracted. Now, whether the properties of judgment debtors and garnishees attached under the MPID Act would be available for the execution of decrees against the judgment debtors in view of the provisions of moratorium under Section 14 of the IBC 2016. The Honorable Court held that the properties of the judgment debtors and garnishees attached under the provisions of the MPID Act would be available for the execution of the decrees against the judgment debtors by the Supreme Court Committee, despite the provision of moratorium under Section 14 of the IBC. So, friends, we conclude. It was thus concluded that both the orders passed by the Supreme Court Committee on 10th of August 23 and 8th of January 2024 stand vindicated and upheld. So, friends, we conclude here that the Honorable Supreme Court has protected the interests of the depositors and the investors. So, friends, I trust that you find this both interesting as well as helpful. So, for further insights into such judicial pronouncements under the Code IBC 2016, Please like this video and subscribe to my YouTube channel. So thank you friends for being with me here today. This is Deepika B. Prasad signing off and will catch you in the next case. Thank you.